My name is Andrew Trask. I'm with Shook, Hardy & Bacon's Los Angeles office, and with me I have Tom Sullivan, who's a partner in their Philadelphia office. And today on Class Action Quick Hits, we're going to talk about Bristol Myers Squibb motion to dismiss, which has in the last few months seen a fair amount of action at the appellate level. This is a matter of great interest to most class action lawyers, has been a tactic that's been around now for about 1.5 to 2 years. Will probably go away fairly soon, but it's not all bad news. At the same time as we have several rulings that say that this motion may no longer be viable, the logic they're relying on is giving us a fair amount to work with in the class action context, both at certification, at discovery, and even up at the appellate level. So what was the Bristol Myers Squibb motion to dismiss? It was a motion to dismiss that was based on a Supreme Court opinion, which was Bristol Myers Squibb versus Superior Court of California. That had been a mass tort case that had arisen in the multi-district litigation, or MDL, context. Specifically, it was a case that had involved a number of plaintiffs who were not members of, or who were not properly venued in the court in which the litigation had been consolidated, and had not filed directly to the court, but instead had tried to file in areas that they weren't properly venued in. The defendants in the case moved to dismiss them for lack of personal jurisdiction, specifically that the court didn't have the power to hear these people's claims. And after doing a proper personal jurisdiction analysis, one of those full ones that you may remember from your first year civil procedure class, both the district court and the appellate court held that they were correct, that they did not have personal jurisdiction, and dismissed the case. So specifically, what they looked at were plaintiffs that filed from a different state, or filed in a federal court in a different state than the state in which they had suffered the harm or were residing, which were usually considered to be the same thing. They held that you have to find personal jurisdiction for each plaintiff. One plaintiff can't simply join people from out of the jurisdiction in order to confer that jurisdiction. And they held that general contacts were not enough, that you have to establish specific links with the state in which you're filing in order to establish the state's general personal jurisdiction over your claims. Obviously, if you have specific links that provide for specific personal jurisdiction, that would work as well. This has been a fairly helpful case in the multi-district litigation context, in particular because it allowed the defendants there, or the defendants in that context in various cases, to make sure that the plaintiffs are filing in the proper courts to begin with before things are consolidated. But a question arose that a number of enterprising defense lawyers wanted to have the courts answer, and that was, if this applied to relatively minor claims asserted by relatively minor plaintiffs in MDLs, could it also apply to absent class members in class actions? In other words, let's say you're in the Northern District of Illinois, and you have a Northern District of Illinois named plaintiff, but he's asserting claims on behalf of a nationwide class. The vast majority of the class members are going to be from the 49 other states in the United States and the District of Columbia. They would probably not have personal jurisdiction to assert their claims in the Northern District of Illinois. And the question became, could you dismiss the class claims at that point if you didn't have the personal jurisdiction or the specific jurisdictional links for these absent class members? A number of defendants in a number of jurisdictions asserted this argument over the past 2 years. They largely met with failure. Most courts did not want to get into the deep analysis on it, but also had varying reasons, going from it's an inappropriate inquiry at this point to we don't think that absent class members are actually parties, to answer in the negative. One exception here was the Northern District of Illinois. In that particular jurisdiction, 2 judges granted motions to dismiss class claims, actually motions to strike class claims on Bristol Myers Squibb grounds, as everybody referred to them. And that emboldened more plaintiffs or more defendants in the Northern District of Illinois to file those motions to dismiss, and also emboldened defendants in other areas as well. Over the course of 2 years, what we began to see was a series of opinions outside of the Northern District that said, this seems popular in the Northern District of Illinois, but nowhere else, and we are not going to go against the vast majority of cases. Within the Northern District of Illinois, several judges began to peel off from the mass that had begun and to rule in the opposite direction. And what that led to ultimately has been 2 appellate cases, one in the Seventh Circuit, an appeal from the Northern District of Illinois, and one in the District of Columbia Circuit, or the Circuit for the District of Columbia, which was an appeal from a DC case. And those two appellate opinions were rendered in the last 3 months. And Tom is going to give us some background on those. Tom?
Thanks, Andy. So these two cases, the one arising out of the Northern District of Illinois and decided by the Seventh Circuit is a case called Musset versus ICVIA. And that was decided March 11th. And the other case we're going to talk about is Moloch versus Whole Foods, decided by the United States Court of Appeals for the District of Columbia Circuit. It was decided March 10th. Some of the facts on Musset importantly a TCPA class action. And in this case, ICVIA, the defendant, was a Delaware corporation with Pennsylvania headquarters, so sued in the Northern District of Illinois in a TCPA putative TCPA consumer class action. So not for purposes of jurisdictional purposes, it was not at home, so to speak. The court, the Seventh Circuit here, really took its cue from the Supreme Court case Devlin versus Scarletti, which was a case in which there was actually a certified class. Here, in Musset, there was no certified class as of yet. But in Devlin, that case involved an attempt to intervene in an appeal in a case that involved a certified class. The critical part about that is that the Supreme Court held that for some purposes, absent class members may be parties and for others not parties. And that is the reasoning that Musset really uses to hold appeal that BMS did not apply in the context of this class action, and therefore reversed the district court. The other interesting thing about Musset is that it really emphasized the fact that this is an issue that had not come up in class action practice prior to BMS. So, in other words, BMS sort of injected this personal jurisdiction issue about absent class members into class action practice. And the underlying tone of the opinion was basically that, this is how it's been for a long period of time, and there is a reason for it. And tying that into Devlin, the reason is that these absent class members are not yet parties, and therefore we need not worry about them for personal jurisdiction purposes at this time. Likewise, the Moloch case, Moloch versus Whole Foods, that arose out of the District of Columbia, was an employment class action. And in that case, Whole Foods is a Delaware corporation. Principal place of business is in Texas. So again, not at home, so to speak, in the District of Columbia, and was sued in an employment case by a putative class, seeking compensation relating to the incentive bonus program that Whole Foods operated under various state laws. And in a lengthy analysis, the Moloch court goes through prior Supreme Court cases like Smith versus Bear Corporation, in which the Supreme Court said that absent class certification, putative class members are not parties before a court. And also, like the Musset court, relied heavily on Devlin versus Scarletti to making the point that until certification, an absent class member is not a party. So they're not a party before the court. And basically reached the same result as the Musset court in reversing the district court's dismissal here. It did not, as the Musset court did, emphasize the fact that this really hadn't been part of class action practice, but it did cover a lot of the Supreme Court cases that relate to the fact that an absent class member is not a party until a class is certified. Andy, this has some important implications, I think, for going forward in terms of class action practice outside of the motion to dismiss context or motion to strike context, which is how the issue came up in these two cases. You want to talk a little bit about that?
Sure. And this is actually why I think these cases are still fascinating. I mean, yes, there was a litigation trend here for a specific type of motion to dismiss. And the primary takeaway everyone has from these two cases is that argument is likely no longer available to us. At the very least, 2 out of however many 13 appellate courts have weighed in and said so far that it's not going to be a viable argument. However, the logic that they used, particularly the DC court or the DC circuit, Malik, but also to an extent the Seventh Circuit in Musset, is that the reason why this particular motion to dismiss won't work is because you're moving to dismiss people who aren't parties to the litigation yet. Before certification, absent class members are not parties to the litigation. The appellate court for the District of Columbia specifically says that, and the Seventh Circuit comes very close to the same logic. And the DC Circuit in particular relies on a series of Supreme Court cases that have all been very clear that the dividing line between a class and an individual with big hopes and dreams is the certification process. Prior to that, you have an individual lawsuit. After that, you have a class action. So that means the following things. Communications with pre-certification absent class members are very likely allowed. Now, the Supreme Court has already said that in Belfoyle versus Bernard, but these particular cases reinforce that logic. Prior to certification, you're not communicating with absent class members. You're communicating with people who aren't even parties to the litigation. And that means both plaintiffs and defendants can feel free, unless they're saying something misleading about certification, to communicate with absent class members for the purposes of discovery and for the purposes of even making settlement offers, for example. And I shouldn't say absent class members. I should use the proper terminology, which is putative class members. That's what's often used at the certification stage. And what we're learning here in these cases is that's absolutely the proper nomenclature. Proportional discovery is another one where there is a certain amount of discovery that one might need because there's going to be a class certification hearing. But when you determine the size of the lawsuit, you're not looking at a certified class of several million versus a corporation. You're looking at between 1 and 20 people who are bringing a class action against a corporation. And that's a significantly smaller group. Even the fact they have an extra hearing in there is not going to give them the same proportional weight and entitlement to discovery as just 20 people would. So in evaluating the stakes during discovery disputes under the amended 2015 civil rules, you're going to have a much stronger argument for limiting discovery for undue burden grounds or on undue burden grounds. Another thing that we see just constantly, even as a baby lawyer, I saw it in some motion to dismiss hearings was, both sides walk into the room, the defendant will move to dismiss and will argue the law, and the plaintiff will get up and the first thing they'll talk about is the class and the fate of the class and how you don't want to take these millions of people and deny them relief. And this just reinforces that that is a rhetorical gambit that likely can't succeed. And the more cases one has to cite and rebuttal there, the better off we are. We now have several appellate court opinions that very specifically say you're not denying an entire class relief. You're denying an individual their shot at getting a class certified. But if there really is a certifiable class that has a viable legal claim, maybe some other plaintiff will think of it and we can wait for them. And that's an important rhetorical distinction to make. And it's, while a relatively small advantage, an advantage that one can bring into the court itself. The last thing that it's actually useful for, at least right off the bat, are a number of cases lately in which class action plaintiffs' lawyers have brought and have made attempts to get themselves appointed as class counsel early in the litigation. They'll usually do this for one of two reasons. Reason number one is because they are competing with other class counsel in other cases that are based on similar allegations to be the lone voice that talks to defendants. This can make settlement much more difficult. It can make certain other negotiations like consolidation much more difficult. The other reason often is because the counsel just want to have themselves appointed in order to deter other cases from coming forward. Now, it's not that as defendants we want to see loads and loads of class actions filed against us, but if there are 4 or 5 class actions, 2 or 3 of which are helmed by people who are reasonable and willing to talk on a reasonable basis about scheduling, discovery, and settlement, and 2 or 3 who aren't, it's better if you have the opportunity to talk to them all on an individual basis. Somebody arguing for a class counsel appointment prior to certification is asking to be appointed counsel for a number of actual represented parties out there who would be members of this class, but who haven't yet designed or who haven't yet come over and asked for this particular counsel to be their counsel. So on those particular arguments in which it always seemed like the defendant didn't have much of a stake, the defendant now appears to have more of a stake because essentially they can come in and say, look, we're facing several of these. We don't want you to appoint this person as counsel for the entire class because the entire class doesn't exist yet. And until certification, you've got a number of lawyers who are all hoping to be class counsel. And we'd much rather have a good, proper Rule 23G evaluation that's adequately briefed and supported by facts than a quick motion right now done in this court by this counsel to try and freeze out the 4 or 5 others that we've got out there. So those are the implications of having a ruling that says that until certification, the only party in the litigation is the individual who's named in the lawsuit. Unnamed class members are putative class members, and they are not parties. And that the more we can get courts to say that, the better off defense counsel are in general when trying to get a reasoned, fair decision on class certification and on the various procedural maneuvering that leads up to it. And that's pretty much what we wanted to tell you about this particular set of cases. Right, Tom?
That's great, Andy. I think we haven't seen the last opinion from an appellate court in this area probably, but I think it's good news that, for any defendant, that even when you lose on appeal, you can still use that ruling in your favor. And I think you really covered a lot of the areas in which we can use this as an arrow in the quiver moving forward.
Well, with Tom Sullivan, I'm Andy Trask. Thank you for taking the time to watch this, and we hope to see you again soon.